are those of the show personalities and guest alone, and not those of Vic Canellis Media Group, its parent, affiliates, or stations. VCMG Live is not responsible for any content, information, or opinions expressed. User bears full responsibility for their reliance on such content, information, or opinions.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Good evening. We are in South Florida. Yes, we're in South Florida. See, this is what happens when you've got 8 different markets, and now we're also in New York City now. But tonight we are live here from South Florida. I got to tell you, and sometimes I get speechless with this. This show, which we also do the first of each month, I have never seen a show so hot before that so many of the listeners write in. We broke a record again this month for how many of you all wrote into the show with your questions as we're talking about community association law. So if you live in a condominium, an HOA, you do not want to miss tonight's show. And I'll bet you with all the questions we've gotten, we are going to hit one of your questions, and you can call in live right now at 888-565-1470. 888-565-1470. We take live calls and we read your questions. Tonight, we're lucky we've got board-certified attorney Peter Mullengarden. I hope I said that right.
Mullengarden. That's close. It's a long name.
Hey, listen, if you knew what my name was, you'd see why I go Steve-O. So, good evening, Peter. I think this is your second show.
This is my encore. Repeat.
Yeah, that's right. So, tell people a little bit about K. Bender Rimbaum.
Well, K. Bender Rimbaum is a full-service community association law firm. We have 8 attorneys who are board-certified in condominium law, like myself. Our offices are in Pompano Beach and in Palm Beach Gardens, and I work out of the Palm Beach Gardens office. We represent associations throughout South Florida, but also on the West Coast and now into Orlando, where our new office is.
Nice, because you're in Tampa also.
Yeah, right, the West Coast side, right. So, we're all over the state for the most part, and like I said, we specialize in representing condominiums and HOAs. That is our primary business. And I've been doing it myself for 38 years. Lucky me.
You're a newbie.
I'm a newbie.
You're a newbie.
Age is but a number, right? So that's us.
Well, we're going to go to the phones. The lines are already ringing already. Our first call, you should love. I believe he's an attorney also. I might be wrong. Let's say good evening to Barry. Hi, Barry.
Hi, how are you? Steve-O, Peter?
Doing
Peter's
well.
Hi, Barry.
Steve-O and Peter are my friends. I'll make it very short. I sent Peter an email a few minutes ago with a chart. It was sent to me by Robert Nordland, who's the president and founder of Association Reserves, which is the largest reserve study company in the country. They prepared over 70,000 reserve studies. And this chart says that 54% of condos are less than 50% funded in 2021. And that does not bode well in the future for many, many condo owners. That's my comment, but Peter will have some comments, I'm sure.
Yeah, what, Barry, do you have something else?
Yeah, go ahead, Peter.
No, that's it. That's
Okay.
it.
What Barry is, what his comment really pertains to is the new changes to the law, to the Condominium Act, basically dealing with reserves, in which now associations are required to prepare a structural integrity reserve study, which is basically a very comprehensive reserve study. Any association that's in existence really now must have it prepared by the end of 2024, really governing the whole building, but most importantly, the structural components of the building. And the law also provides that the structural components of the building, which includes anything from the roof to the to the foundations, the walls, the electrical, waterproofing. There's a whole list. Now that those things, basically, the associations have to fully fund them, and they cannot waive them, and they cannot vote to use them for other purposes. So what Barry was getting to point at is we have a lot of associations in South Florida. He read off, I think, 54% that are currently, underfunded, and these associations are going to have to basically get themselves on track, pursuant to this reserve study, to be on track to be fully funded. Not mean that they have all the money right up front, but they have to be on track to replace these components at the times when they're going to come up to be done, depending on the life of the component. Without getting too deep in the weeds on this, his comment is that this law, which is obviously a reaction to the Champlain Towers South, tragedy down in Surfside, the state has now required these milestone inspections, and on top of the reserve study, a milestone inspection being an inspection regarding the condition of the property, the reserve study for the reserves. So, without speaking the whole show on this one on this one comment, I think Barry's comment is again that there's going to be potentially huge financial impact on many people living in associations trying to fund the reserves.
Hey, Barry, thank
Yeah.
you so much. We got a board full of calls right now. We're going to go to Joan in Fort Lauderdale. Good evening, Joan.
How you doing? My question is, can the board add restrictions to renters' leases? In other words, do we have the right to say, hey, no pets and no smoking? Do we have the right, or do we have to put it up for a vote in the membership?
To add restrictions in your documents regarding leasing in terms of who can lease or how
Well, not
frequently
the
they can lease?
documents, in the actual lease. The owners all have different leases, but we would like to restrict the renters from having pets and smoking. Can we do it?
If you're going to do that, you're going to have to do an amendment to your documents, most likely, basically providing for those types of restrictions with respect to leases. I don't think you can just, the board just can't pass a resolution saying these things have to be, in my opinion, anything dealing with leasing, rental, any kind of restrictions on duration. Now, this isn't a restriction on duration. In other words, how long the lease term is, or how frequently that they can lease. But if your documents address leasing in any manner, then that really is a subject for a vote through your declaration and not just a board resolution.
Well, the documents on leasing very vague. That's all. It doesn't get into the specifics.
I'm just
So we
saying,
still
but your
have to get a
document,
vote for the membership.
from what I'm hearing you say, I would do a vote through the membership. Yes.
Okay, thank you.
Thank you, Joan.
Sure.
We have a line open now, 888-565-1470. Let's go to Lynn in Lake Worth. Good evening,
Hi,
Lynn.
Peter. Actually, I have two questions.
We
Hi,
won't
Lynn.
charge you.
Hey there.
Maybe.
So, I have an unruly board member, and per my documents, it already states that any officer may be removed from the office with or without cause by the board. What would your next step recommendation be?
This is, okay, you have an unruly board member who is also an officer, right?
Yes.
Okay. Most documents provide, most bylaws provide that, yeah, officers can be removed from office by a vote of the board. In other words, you can take a president out of his or her office as president, vice president, treasurer, etc. The board cannot remove someone from the board, though. Okay, so that person would remain on the board, although you could take them out of their office. In order to get someone off the board, they need to be either disqualified because they don't qualify anymore under the law or under your documents. Otherwise, they have to be recalled, and a recall is a vote of the membership of the association, and it's a majority of the voting interests can recall someone. It's not easy to do. So the board just can't simply remove another board member.
Okay. May I ask a second question?
Go ahead.
Sure. He said no charge, but we'll go with that.
So obviously every HOA has emergency situations, and I'll give a prime example. We had a significant rainstorm on June 4th, and we had major roof leaks. So obviously there is a decision that sometimes has to be made in the moment and doesn't get board specific approval at that minute on what the next step needs to be. Let's just say for them to come in and remove all the water from inside the clubhouse. So is there an issue with that if it's brought in and an email is sent right after the situation happens stating what's happening and what we're doing, and now we're approving the invoice at a meeting?
Yeah, I mean, if you have a bona fide emergency, okay, where waiting is going to either cause damage or exacerbate the damage, then in my opinion, the board can act immediately, because it needs to act immediately, because it can't wait 48 hours, for a typical board meeting notice. Again, but it has to be a bona fide situation, and I'll leave that up to your good judgment.
Okay.
The board can then always later ratify. Okay, and I don't use ratification lightly. I don't, to lean on it too heavily. But the board can ratify what it did, can ratify the invoice, can ratify the payment, can ratify the action. But the actual action itself, again, if it has to be done immediately, it has to be done immediately, because you got water pouring in through a roof, right? So I don't have an issue with that.
Awesome. Okay. Well, thank you so much.
Lynn.
I appreciate you having me.
Thank you, Lynn. Thank you.
Thank you.
Let's go to Darlene in Port St. Lucie. Good evening, Darlene.
Good evening. How are you?
We're doing well.
Hi, Darlene.
Hi. I as well actually have two questions. My first question is, the members of our HOA received a document that was found in a box dated 2017 by a board member, and I had read an article where it said that if a document had not been enforced for 5 years, they could not enforce it now, and I just wondered if that was accurate.
Well, it's not exactly accurate. I'm not sure what document was found. I don't know if that was, a recorded document or some rule or policy.
At the time, no, it was not recorded.
Okay. Because there's a 5-year statute of limitations with respect to when you're trying to enforce a provision of your document. So it's like, someone's in violation of something, and you wait 5 years. There's a statute of limitations to enforce a contract, and these documents are considered to be contracts. Okay. The other time period they may come in is something called latches, which is an equitable situation, which is not so much a statute of limitations, but where the association simply or the party has waited too long, and therefore that has caused harm or injury by that wait, and therefore the instrument can't be enforced due to something called latches. So here, the 5-year thing, again, sounds like someone was quoting a statute of limitations. Now, what some associations have done when something hasn't been enforced, either intentionally or unintentionally. What they can do to revive that type of restriction or instrument, there's a case out there called chattel shipping versus Brickell Towers. Anyway, and in that case, there was an association that had not enforced a certain provision. It wasn't a 5-year thing, but they hadn't enforced this provision. So in order to get around, to be able to enforce it, because to enforce it against some and not others was selective enforcement. What the case said, what this association did is they sent out a notice to all the owners in writing saying, as of this date, this particular restriction is going to be enforced prospectively. Okay, we're going to allow these other violations, but from this point forward, we're going to enforce it. And the court held that in essence revived that restriction, breathed the life back into it, resurrected it, whatever word you want to use. So now they could prospectively enforce that restriction using this chattel shipping resurrection process by basically saying, everyone be on notice. This hasn't been enforced, but from this point forward, it will be.
Okay, here, it was an architectural, what was it called? Standard.
Architectural standard?
Yes, and it was put on there by the master contract, but it was never voted on by the people, which that's another question. Did it have to be voted on?
I mean, it's tough here on the radio, unfortunately, to answer some of these questions without reviewing your documents. And I'm, just want to say that, we try to answer questions generally. And some things, I obviously I'm not looking at your documents. So I don't know, quite frankly, whether what you have is even enforceable in the way it was done. And I can't address that. Okay. I don't know if it should have been recorded. I don't know if it was properly adopted. So I can't really address it. I just don't have the time here, and this isn't the right forum for that. But, again, assuming, which is a bad word to use, but assuming that, it was properly adopted, just for whatever reason was inadvertently not enforced, you could resurrect it. Anyone who did it 5 years ago, they're going to be allowed to have it either by statute of limitations or latches or waiver. Whether or not you can do it prospectively, I can't really answer that. If it was a kosher thing, right thing, you can resurrect it. If it wasn't, you'll have to do it right. Do it right. But I can't answer that question.
See, they're trying to enforce fines on people. Is what they're trying to do.
I understand what you're saying. Unfortunately, I just can't get into that kind of specific and tell you whether those fines are going to be good or not. This is something where call K. Bender Rumbaum and hire us. I'm not trying to be flippant, and I'm not trying to dodge your question at all. I just don't know without really looking at it, and that's why we do what we do for a living. I really can't answer whether those fines are proper or not. I don't think they can find 5-year-old violation, okay, quite frankly. But I don't even know whether that provision is going to be enforceable or not. I just don't know.
Okay, thank you, Darlene.
Okay.
Let's go to.
Thank you.
Can I ask one more quick one?
We got a board full of calls we got to get to.
We're going to move on to the next one. Thanks, Darlene.
We're going to
Okay, thank you.
Katharina in West Palm Beach. Hi, Katharina.
Hello, good evening.
Good evening.
Hi.
The community that I manage, there's an issue with trucks that the docks do not allow for pickup trucks, but the previous managing company did not enforce that. And now I have the job of enforcing it, but I'd like to prepare a chattel shipping letter to enforce it. Does that need to be prepared by an attorney?
Doesn't have to be, but it's probably wise to do so. I'm not trying to shill for my profession. But if you want to, have some comfort level, I mean, obviously it's not something that's recorded. It's not like a lien or it's not like an amendment, but, and it's funny you asked about chattel shipping because that was the last question. But I would probably at least run it by your attorney or the association's attorney just to make sure that I's are dotted, T's are crossed, so that when you go forward, there won't be any issues.
Okay. Okay. Well, thank you.
Thank you.
Sure. Good luck. Thank you.
We got to go to
Yeah,
break.
chattel shipping is an interesting case. It's come up twice now. So, it's how to keep your documents alive, in essence, when they've become unenforceable, your restrictions.
Peter, can you give everybody the phone number at the office?
Oh, phone number. Well, because I'm always so terrible at doing those kind of things. Our phone number up here in Palm Beach Gardens, and actually you can reach the Palm Beach, you can reach the Pompano Beach office this way too, is 561-241-4462. That's 561-241-4462.
And you can also go to the website, which is KBRlegal.com. That's KBRlegal.com. If you have a question for Peter tonight, this is the time to call in. You can call us at 888-565-1470. Give us a call. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. This is the Ask the Expert show with you every Thursday night, drive time 6 to 7, where we bring in South Florida's finest experts in the fields of legal, health, financial, and home improvement. Tonight, our attorney tonight with the K. Bender Rembaum Group, I can actually say that he is an expert because he's board certified. If you're not board certified, you are not allowed to call yourself an expert. So we're lucky to have Peter tonight with us. Again, K. Bender Rembaum will be back with us again next week also from 6 to 7. If you have a question tonight for Peter, you can call us at 888-565-1470, and we will be more than happy to take your call. Getting a lot of calls tonight. Let's go to Douglas in Vero Beach. Good evening, Douglas.
Thank you, gentlemen. Thank you, Counselor, for your public service here.
Is this your cousin?
Cousin Dougie! No, it's not.
No, but I wish he were. I'd love to talk to him more. But
Hi, Douglas.
Hi, guy. Our condo association management company recently stated that fines for violations of various no-nos in our governing documents are not lienable. And I thought, I don't think that's correct. Or in my experience, more of my experience been in HOAs, but this is a condo.
Yeah, well, they're right. Under the Condominium Act, fines are not lienable.
Wow. So that's kind of a shocking concept, but I'm sure you understand it. Could you address then what happens and how can that be and so forth?
How can that be? Well, you have to address that to your legislature. But
Oh, I
for
understand. I
whatever reason,
understand, but
the Condominium Act, and it's been this way for many years, it does limit the amount of fines, and it expressly says that the fines may not become a lien against the unit. In the HOA Act, as you alluded to in Chapter 720, it's possible, but the fine has to be $1,000 or more. So in an HOA, you can have a lien, in my opinion, if your declaration authorizes the lien for a fine, but by law, it has to be at least $1,000 fine, and there's various ways to get to that amount depending upon your documents. But why are the
sure.
lien? Why? I've always had this question myself, Douglas. To be honest, I mean, I've
Yes,
always said
yes.
that taking out the lien authority from a fine kind of takes the teeth away from it, right? Okay,
Absolutely.
but I don't know if the state is concerned about due process, in essence that that they don't want to allow associations to fine just on a decision of some committee and a board, and they could abuse that authority, that power. I don't know if that's true. That's just my supposition that they don't want to, but why is it different for an HOA? Again, ask your local legislator because I'm not sure.
Or it might be the Speaker of the House lives in a condo while he's in Tallahassee.
That, you know what, you say that in jest, but some of these laws are exactly the result of a legislator who has a bad experience with his or her association, and because they're in that position, they get a law passed. It just happened last year. It happens.
I'm a former legislative staffer, staff
Okay.
director, in fact. I absolutely concur. You're very kind. May I just ask one related question? We slip over to the HOA side, which we just said can be lienable. They are lienable once they reach the maximum. The issue is very current. Someone, let's say it's parking violations, and yes, it's 100 a day up to the 1,000, but and we lien that. Is it possible then to start over, because they seem to just love to park in the yard and they don't seem to mind paying or being liened against? But isn't it possible for us to start a new?
Yeah, I think. Yeah, I mean,
Yes.
I think if the violation continues, crank up another violation.
Well, that makes sense to me, logical sense. I talked to a board member the other day that is of the mind that, no, you can't do that. You can just once. And I thought that makes zero
Well, I don't
sense.
look. Different lawyers may have a different opinion on
Sure.
it. But
They're not a
somebody
lawyer.
in my own firm might disagree with me, and that's okay. But
Sure.
I'm not sure. I mean, the statute itself doesn't seem to say that you're just one and done. So
It makes no sense, but we just basically agreed it makes no sense over in 718 either. At least it
That's
hasn't
true.
been explained to us yet. But it, that's what it is. So I do appreciate your kind patience and
Douglas,
really
thank
what
you. You're a good caller. Call back again.
Thank you,
I'll
Douglas.
do that. God bless you both. See
God
ya.
bless you.
Yes.
Let's go to our next. Got another Port St. Lucie. Steve. Good evening, Steve.
Good afternoon. Thanks for taking my call.
You're welcome.
Hi, Steve.
My question is, in a duly elected board HOA with 7 members, can the president take it upon herself to submit documents to the declarations, and can she just go around appointing people at her own bequest rather than getting a vote from the board?
Appointing people as what?
And on committees, like the ARB or finance or any of the other committees.
Well, I've seen some documents that give a president the authority to do that. That's kind of the outlier. Typically, a committee is created by the board, and the board chooses the members of the committee. Typically, that's not a presidential duty. Okay. And also, if you think a president, I mentioned this, I guess two or three calls ago, or maybe 3 calls ago, if an officer is abusing his or her office, under almost every set of bylaws I've ever seen, the board can take that person out of that office. They're still on the board, but they're no longer president. So some associations are reluctant, or boards are reluctant to use that to rein in a rogue officer. But that's really the most effective way to do it.
Yeah, I just don't understand why you elect a board if one person's going to take it upon themselves to insert documentation into the declaration. That should be
generally they can't. Generally they cannot. Generally, committees are appointed by the board, and the members are can be of the committee can be changed by the board. I've seen some bylaws that give that authority to the president, but typically it's through the board.
Right.
Thank you, Steve.
It does take a full. All right. Thank you.
Thanks for calling. Steve. Let's go to Norma in Boca Raton. Good evening, Norma.
Hi, Peter. I know you because where I work in Delray, the certificate of voting for that voting representative says that if a husband and wife own a unit together, that one of them has to be named the voting representative. Where I live in Boca, ours says that if it's a husband and wife that owns a unit together, they do not have to do a certificate and appoint one of them. Which is correct?
Well, there is no correct. They can both be correct. The thing about, let me explain to our audience what a voting certificate is first, so they have some idea. Under most documents, not all, under most documents, they have a provision in the bylaws regarding who is authorized to vote for a unit. And this is both for HOAs and for condominiums. And usually this section or this provision comes into play when you have a unit that's owned by either by multiple individuals or owned by a corporation or some other entity. Now, there's nothing in the statutes about voting certificates. It really is governed by your documents. So in some documents, it will provide that if a unit's owned by more than one person, they have to designate which one of them is authorized to vote for the unit in something called a voting certificate. Okay? Some documents just say either one can vote, and you don't need a voting certificate. With husband and wives, I've seen both. I've seen many instances where there's what I call the husband-wife exception, where it says if a unit is owned both by a husband and a wife, either can vote, and they don't have to designate which one is authorized to vote. I've seen others, I guess like the one you mentioned, that require husband and wives to designate a voting person, just like if the unit was owned by two brothers or two sisters or whatever, non-spouses. So the short answer to your question is it really depends on what the bylaws say. They control this 100%.
And if the bylaws do not address it, they can just do what they want?
I wouldn't say they can do what they want. I mean, if it's silent, I would say that anyone who's on that deed, any owner can vote for that unit. I'd have to read the bylaws again, but typically the voting certificates are very, those requirements are very specific. I would say if it was silent, then any owner could then vote.
Okay. All righty. Thank you much.
Thank
Talk
you.
to you again. Bye.
Okay.
We have a line open now at 888-565-1470, 888-565-1470. If you have a question for Peter, K. Bender Rimbaum, they have been with us now for almost 5 years. They do the first show of each month from 6 to 7, and we have been lucky enough to also add an additional show from 6 to 7 the last Thursday of the month. So again, give us a call. We're going to start going to some of these questions that you've written in. 888-565-1470. I don't know if, Peter, do you have the schedule of what you're doing this month? Or next, actually.
Oh, in terms of our
month?
speaking? Oh.
Okay.
Our class?
We won't do that.
No, but go to our website. The website has the schedule.
Very good. That's the best way to
I'm going to get an F for marketing here. I'm going to get a F minus in marketing. But go to the website.
So let's go to our first question. If a board member resigns, does the open seat have to be filled by the members that ran for the board but did not get elected?
Yeah, that's actually a frequent question and a frequent misconception. So if someone resigns or dies, the under most bylaws, the remaining board members can pretty much choose whoever they want. They do not have to go back to the slate of candidates and pick one of them. They can pick whoever. They're not wed to that prior slate.
We just got a text in from a listener. They want to know if a board member can just walk into their condo.
Only if it's their mother.
Yeah. That's kind of an odd question.
No. I mean, access to the units is limited. Okay, under the statute, there are some various access authority of the association. The principal access is if the association has to go in to either do maintenance or repair that the association is responsible for under the declaration. Under certain declarations, the association declarations of condominium. The association is responsible for maintaining parts of the unit. Could be a window or something like that. So they're allowed to go in, obviously, to do that maintenance. Otherwise, they really can't go in unless it's necessary, okay, to perform maintenance to prevent damage or further damage to the common elements or to a unit. So it's a judgment call that, but they can't just walk into a unit and say, we want to inspect your unit or we want to have an apple,
Yeah.
Have a pie.
We do have a line open right now at 888-565-1470. Let's go to our next question. Stefan from Palm Beach. We get a lot of people asking about, cars that are being towed away.
Right.
Stefan wants to know, what authority does an HOA board have to tow cars parked on common area streets? Do they need to post a 24-hour notice on the car or just a notice at the front of the HOA?
Okay. It is a good question. It does come up a lot. Okay. As a threshold matter, it's always my preference or my opinion that the remedy of towing should be set forth either in their declaration or in their rules. Okay. Just the remedy. The actual towing, a party is allowed to tow cars off of private property. The statute that governs that is section 715.07 Florida statutes. Without going into incredible detail, the bottom line of that is there is a way to do it by giving the vehicle operator personal notice, but that's very difficult. The easiest way to do it is by posting up proper signage. And the signage basically saying that unauthorized vehicles will be towed. The statute is very, very specific, though, on where these signs must be posted, how tall they must be, what lettering must be on there, what content, the size of the lettering. Basically, they have to be posted at every curb access or entry point to the parking area, a certain distance from the road. Again, most towing companies, though, know this cold because they furnish the signs,
right,
usually for you under their contract. So long story short, yes, you can tow as long as you've dotted I's, crossed T's with that statute regarding where your towing signs are posted and whether they conform with all those other requirements.
What about handicap parking? We just had someone wrote, how do I go about getting additional handicap parking? Do I go before the board?
Well, that depends whether they want, if you want handicap parking, I guess that is, governed by the local municipality or the local county or something like that. That's a whole, that's a government thing. Generally speaking, I think that the board probably could, do like a private, I guess, handicap parking spot, against something that's not necessarily, through the government. But again, check your documents. Obviously, you can't take away anyone's parking space. It could be issues with, an alteration of common element issue, but, probably not. So I think the board, Yeah, if someone wants a handicap spot or wants the board to designate one, I think the board most likely could do that through their documents, depending on their powers. Um, but yeah, they should raise that with the board.
You know, Peter, we have an older demographic down here in South Florida, and we get a lot of elderly people who write in that are very nervous. As another insurance company just went under again, and it seems like the less home insurance companies that go out of business, the more the rates go up because they can get away with it then. And with this building inspection for buildings that are 3 floors or higher, people are really concerned about cost.
Yep. My clients have been crushed with the increases in premiums,
Yes.
both for property and for liability insurance on both ends of it. I don't have a brilliant answer for this. I mean, obviously, an association must be insured. You simply, I mean, HOAs is not usually as much of an issue. But for condominiums, I mean, the associations are required to adequately insure the property. And adequately insured means full replacement value less your deductible. And your replacement value has to be ascertained by insurance appraisal at least every 3 years. And I realize it's expensive, and you can try to jockey it a little bit by maybe increasing your deductible or something like that. But at the end of the day, this is one of those fixed costs that I don't have a great answer for. It is a squeeze. You're right. Between insurance, these new reserve requirements,
Right.
and other things, there is a big fear that a lot of people are going to be maybe potentially even forced from their homes because they can't, on fixed incomes and things like that, and they just
Right.
can't. People who bought these units, 20 years ago, when they were 60 and now they're 80 or something like that. I mean, and not even that example. It is a problem, and I wish I had a brilliant answer for it, and I don't. But again, that's something the legislature, they were going to address this insurance situation. I don't think they really have, quite frankly. I don't know if they can, but it is a problem. Yep.
We're going to go to our last break. If you would like information, if you'd like to talk to Kay Bender Rimbaum, the best way is just to go to their website. Everything is there. There's so much great information on there. They're at KBR Legal, KB as in boy, R Legal .com, and anything, and the phone number's there. You can call them. We're going to go to our last break. If you'd like to get in a question before we're come to the end of the show, give us a call here at 888-565-1470. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. This is the Ask the Expert show. We're live here in South Florida. You can hear us on 96.9, 95.3, and iHeart. Did you like that, Freddie? What I didn't do?
Yeah.
Anyway, we're taking your
I
calls.
heart you too.
888-565-1470. We've got board-certified attorney with K. Bender Rimbaum, Peter Mullengarden. I think you've got my name beat, Peter, but anyway, let's, if you got a call, we got about another 10 minutes left. We're going to our text and emails. And I got to tell you, Peter, this next letter that I'm going to read, I have not ever heard anybody ask this question before, but Kip in Hollywood says he or she is on the Rules and Regulations Committee at their condo. We are making recommendations to the board on updating them. Do we have to open our meetings up to the residents?
Yeah, that's an excellent question about committees, especially for condominiums. Because for condominiums, and I'm trying to make this answer not too long, but for condominiums, there's two types of committees that always have to have their meetings open to the owners and posted notice, just like a board meeting. That's any committee that's making recommendations about the budget and any committee that's authorized to take final action on behalf of the board, which is not very often. But in addition, under the Condominium Act, any other committee must also have their meetings posted and open to the owners, just like a board does, unless their bylaws exempt that committee or exempt those committees from having to do that. So for Kip's question, basically is unless this Rules and Regulations Committee pursuant to their bylaws is exempted from the open meeting requirements, the posting of the notice and the open meeting requirements, then yes, the meeting must be posted and must be open to the owners.
Okay, let's go. Sharon in Fort Lauderdale wants to know, what is a Phase 1 milestone inspection, and will there be a Phase 2 milestone inspection? Explain a structural reserve study, and will each unit member get a copy?
We should get Barry on the phone for this one.
Yeah, really.
But basically, this is the new stuff that's come in post Champlain. Phase 1 milestone is basically that any condominium that has a building or buildings in it of 3 stories or more in height that is 30 years old. Those closer to the coastline, it's 25 years old, must have what's this inspection basically of the structural integrity of the building. Okay, Phase 1. The Phase 1 is a visual inspection done by an architect or an engineer. And he or she inspects the building, issues a report. It's the milestone inspection report. Basically, what they're looking for is there any substantial structural deterioration going on with this property. If the Phase 1 shows that there is, then you have a Phase 2, also done by an architect or an engineer. The Phase 2 is more intensive because in the Phase 2, it can be destructive testing. It might be non-destructive testing. That's up to the inspector. But the Phase 2 is going into more detail as to what's wrong, what needs to be repaired, giving repair parameters for the building. And so the Phase 1 just goes to see whether there's any structural problems. If there are, then we go into Phase 2. Again, I'm making this a broad brush. The statute obviously is very detailed. Now, those inspection reports, they have to also prepare a summary of them. Okay, so they have to do a full detail report and a summary. The summary must be sent to every unit owner. Okay, the full report must be posted. Also must be posted on the website if they're required to have a website. So yes, everyone gets at least a summary of that report, each report, whether it's Phase 1 or Phase 2. The structural reserve study we talked about a little bit before. That's called the Structural Integrity Reserve Study. And that's a new reserve study, okay, pretty much applies to almost every condominium. That, again, is for the structural components, but it can be other components as well. And that one trying to remember. I don't believe the structure. Don't believe the reserve study. It might be sent to all the owners too. I can double check on that. But those are those studies. Very important that they be done. This is why we're going to be having such costs increased, because these milestone inspections and because of the reserve study.
How are they going to get all these, I guess, people to do these studies, these architects?
That's been discussed a lot among practitioners like myself and others, that there aren't enough engineers, aren't enough architects for the thousands and thousands and thousands of condominiums throughout Florida. Because this is not a South Florida thing. This is a Florida thing.
Yes, right.
So it's everywhere. We'll see. I mean, the deadlines for these reports, for the most part, are December 31st, 2024, which, depending on who you are, the milestone and the structural integrity reserve studies must be prepared by.
Well, hey, let's go back to the phone lines. Let's go to Jeff. Good evening, Jeff. Jeff, are you there?
Guys, how are you?
Good, buddy.
Hi, Jeff.
Peter, you did not fail. You did not fail on marketing. I just got my email working, so I'm just going to let everybody know about a couple of classes. On September 8th, we have the Condo and HOA Board Member Certification course at 12 noon. Lisa McGill is teaching that. And on September 21st, Navigating the FFHA Assistance Animal or Pet with Emily Gannon, also from the Pompano office. You can register for either of those on Zoom via kbrlegal.com and just visit the calendar. And again, Peter, you did not fail. My email was down.
There's my
lifesaver.
There's my memory support.
What's that?
That's my memory support.
I'm your memory support animal.
That's correct.
All right, guys.
Thanks,
Great job.
Jeff.
Let's get back to the question.
Thanks, Jeffrey.
Thanks for letting me in there. All right, bye-bye.
Jeff's a good guy.
Yep.
He's a good guy. Let me see if I can get a couple more questions in here. We have a separate fining committee. This is Jackson and Pompano. We have a separate fining committee. Do they have to open their meetings up to the residents also?
Okay. For a condominium association, I think they do. Again, because of that committee requirement, unless they're exempted. For an HOA, though, the only committees that have to be open are Architectural Control Committee meetings and any committee that's authorized to make a final decision about the expenditure of money. So since the fining committee doesn't fall into either of those categories in an HOA, it does not have to be open.
Jillian in Hollandale has a condo, wants to know, when can the association foreclose on an owner?
All right, I'll try not to make this a 2-hour answer.
Yes.
But basically, if an owner is delinquent in paying their assessments and the association has given them what's known as a notice of late assessment in a proper form, which is a new document required last year, by the way, a legislator who got hit with a foreclosure and required this new this new requirement. So assuming you do the notice of late assessment, and then you start your process, with your attorney with you do a 45-day notice and a intent to lien, and off you go. So long story short, you can foreclose once you put that lien on, give them the proper notices, they haven't paid, and then you can foreclose. I mean,
and they don't want to foreclose on you.
You would think not, but
I got to say, I hope not.
Happens.
But, hey, if you're put in that position. Anthony in Boynton Beach, if there is a designated amount in our budget going into the reserves at our condo, and the board keeps half out for special landscaping, they want to know, is that legal?
That's an odd question. Long story short, reserves, condominium must be designated for certain purposes. You have to, and now with this new reserve study, there's more, but you have to reserve for roofing, painting, paving. You might not be able to waive those reserves now because of the new changes in the law. You're not going to be able to waive them. after December 31st, 2024. I don't really understand when he says keep half out. Reserves are reserves. You can't switch them to other purposes. You can't use them for other purposes without a vote of the owners. So if I understand his question right, I'm going to say no. It sounds like they're trying to just move reserves away.
Right. If the DBPR finds our condo board in violation of the way they conducted our last election, do the residents have the right to know the outcome?
Yes. I mean, it may have to ask. Sometimes the orders from the DPBR require that the decisions be posted. Sometimes they don't. Sometimes the DPR requires that the decision be sent to the owners. At the end of the day, though, if an owner asks to see it, they're entitled to get it.
Okay. Peter, another great job. Again, if you'd like to contact, you can go to www.kbrlegal.com. Anything you want to know is right there. And then we'll have Mr. Robert K. with us next week, Attorney Robert K.
Peter, big dog.
Yeah. Peter, great job tonight. And we'll see you all again next week with more Ask the
Thanks, everybody. Have a great
Thanks,
night.
Peter.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.
The opinions expressed on the preceding sponsored program were strictly those of its host, guests, and callers, and not